Ladies and gentlemen of the jury, we are in this courtroom today because Officer Waldman's last resort measure became his first choice. You've heard the story today of how Robert Ramirez, my client, was shot in the back by Officer Waldman on the morning of December 7, 1996. Officer Waldman ran around his car with his gun ready and shot Mr. Ramirez in the back. The bullet landed extremely close to his heart, only inches away from killing him. It's only by the sheer luck of the situation and the skill of the doctors involved that Mr. Ramirez is here today. And he is here today. He is here and he is pleading with you to punish this officer who so negligently shot him, causing him great injury and pain. Chicago Police Training Manual states that the use of deadly force is allowable in some situations. It's allowable to prevent death or serious bodily harm to either the officer or to another person. However, the statute goes on to say that the use of a firearm in any situation is to be the last resort measure only after all other possible options become unavailable. The statute goes on to suggest some of these other possibilities. Perhaps yelling a warning, "Stop, police." Perhaps firing a warning shot into the air. Perhaps even engaging in the fight himself. But ladies and gentlemen, the facts indicate that Officer Waldman considered none of these as the last resort measure became his only choice, his first choice. Mr. Ramirez said in his examination that as soon as he heard Officer Levy say, "Stop, police," he immediately stopped fighting, went onto the ground, and stopped engaging in the fight. Officer Waldman could have easily said, "Stop, police," in an attempt to subdue Mr. Ramirez. Mr. Ramirez never heard him say this. Officer Waldman could have fired a warning shot into the air. This would have had the effect of alerting Mr. Ramirez that something was wrong. He didn't want to get shot. If he heard a warning shot, he would have immediately stopped fighting. Officer Waldman also could have engaged in the fight himself. He stated in his testimony that he was only 3 feet away. It would have been 2 officers on 1 man. Could have easily grabbed him and pulled him off, thus neutralizing the whole situation. But no. Instead, Officer Waldman, as soon as he saw the confrontation starting, pulled out his gun, ran around the car, and in point-blank range, shot Mr. Ramirez in the back. Now, the officers tell a story that Mr. Ramirez was holding a knife at the time that he was shot. In fact, this knife that you see here in court. However, Mr. Ramirez claims that he never owned this knife. He never saw this knife before in his life, nor had he ever seen one like it before. In addition to Mr. Ramirez's testimony, there is a mountain of forensic evidence that points to the fact that this was not Mr. Ramirez's knife. First, the police report states the knife was found closed on the ground. As was demonstrated by Officer Waldman during his cross-examination, it is shown that in order to close a knife with a locking blade, there must be significant pressure asserted on the base of the knife, while also asserting pressure on the blade of the knife. Both Mr. Ramirez and Officer Waldman agree that as soon as Mr. Ramirez was shot, he immediately fell to the ground, unconscious. If this was the case, Mr. Ramirez would not have had any time to close the knife, would not have had any time to wipe the knife. That leads me to my second point. There were no fingerprints on the knife. Officer Waldman, in his cross-examination, stated that it is likely, in most situations, that a knife being held over someone's head ready to plunge it into them would have some fingerprints on the side of the knife. None were found. Further, no blood was found on the knife. Officer Waldman again admitted that in this type of situation it is likely that there would be at least some residual traces of blood or DNA on the knife that would be conclusive to prove that it was stabbed into someone However, these were not found. Further, Officer Levy, claiming that he was stabbed, was unable to produce the shirt he was wearing at the time of the trial. This shirt would have proved that a knife had indeed gone in and stabbed him. There would have been a cut in the shirt. However, this was conveniently thrown away. Mr. Ramirez, an honest man, a man just trying to do his job, made a mistake. He engaged a police officer, but he didn't do it violently. He didn't do it to kill anyone. He didn't do it to hurt anyone. That was the last thing he would want to do. He was engaged in a fistfight. As soon as he heard police, he fell to the ground, and as he was getting up from the ground, he was shot in the back by Officer Waldman. This story is confirmed by expert Dr. Alfred Angrist, who you heard testify tonight, who said that the most likely scenario, based on the downward path of the bullet and the jagged edge of the wound, is that when it was fired, Mr. Ramirez was in a downward position, moving upwards. This is the most likely scenario of what happened. Mr. Ramirez has suffered countless pain and injury as a result of this shot in the back. He's a single father, working to support his son and also to develop a relationship with his son. Mr. Ramirez testified that he has not been able to do as much work as he was able to, in addition to being off work for almost 6 months after the gunshot. Now that he's back at work, he testified that it is incredibly hard to engage in his type of work, lifting sheetrock over his head, and that he can't do it without significant pain. This single father seeks to develop a relationship with his son, and in his testimony he stated that the way that he loved to do this was to play basketball with his son, to go outside in the front yard and throw a few hoops. But because of this gunshot, Mr. Ramirez cannot do this without pain. Ladies and gentlemen of the jury, Officer Waldman knew the statute. He admitted so much. He knew that the use of a firearm was to be the last resort measure, yet as he ran around the car, he had already had his gun drawn, prepared and willing and ready to shoot. This shot went way beyond his duties as a police officer, as there were other options available to him at the time. This shot caused substantial injury to Mr. Ramirez. Yes, they claimed there was a knife, but you heard Officer Waldman say that without the knife, he would have had no reason to shoot the plaintiff in the back. There was no knife that belonged to Mr. Ramirez. Yes, there was one found there, but there was no evidence that it belonged to Mr. Ramirez. Mr. Ramirez was not stabbing anyone. He wasn't about to kill anyone. He did not deserve to get shot. Ladies and gentlemen, when you are deciding this case today, you must apply what's called the preponderance of the evidence standards, which means that you must determine that it is more likely than not that Officer Waldman overstepped his boundaries as a police officer and acted negligently in the situation. I believe that the facts of the case, the testimony of both Mr. Ramirez and Officer Waldman, as well as the corroborative evidence from Dr. Angrist, prove that there is far greater than preponderance of the evidence. It is far more than likely that Officer Waldman acted beyond his duties, acted negligently, when he pulled out his gun and shot Mr. Ramirez in the back. Please, do not make my client suffer more than he already has. Thank you.